9 Michigan patients, doctors, and reproductive rights advocates are suing Governor Gretchen Whitmer and 4 state officials. They're challenging a little-known state law that they say restricts the rights and decisions of pregnant women. CBS News Detroit's Heath Kalb is looking into that case for us. Heath?
Yeah, Terrence, earlier this year, a woman in Georgia was declared brain dead while 9 weeks pregnant. She was kept on life support for months without her family's consent because of the so-called state-called heartbeat bill, which bans abortions if cardiac activity is detected in a fetus. Now, I spoke to an OBGYN here in Michigan who saw that story and later realized a similar law in the books right here in Michigan.
Which means she was pregnant with a fetus the size of a grape. And at the time, the state mandated that she have to stay on life insurance because she had a detectable pregnancy against her family's consent.
Nikki Sapiro-Vinkir is talking about Adriana Smith, a Georgia woman who earlier this year was declared brain dead while 9 weeks pregnant and was kept on life support for about 2 months against her family's wishes. Here in Michigan, Sapiro-Vinkir says a provision in the Pregnant Workers Fairness Act called the pregnancy exclusion could set the stage for a similar situation.
Which means that if you are pregnant at any stage of pregnancy, all of your advance directive is considered null and void. And that doesn't sit well with me.
Sapiro-Vinkir, along with 8 other plaintiffs, are now suing Michigan's governor and other state officials because they say the provision in the law, which went into effect in 2023, states that, quote, patient advocate designation cannot be used to make a medical treatment decision to withhold or withdraw treatment from a patient who is pregnant that would result in the pregnant patient's death. She says it's a similar law to the one she saw devastate Adriana Smith's family in Georgia, and it's unconstitutional for the provision to be in place in Michigan, even after voters in the state overwhelmingly passed Prop 3, expanding reproductive rights just a few years ago.
We're all so pissed about it and saying that should never happen to anybody in anywhere in the world, let alone in our state where we know that we protect reproductive rights here in Michigan.
The nonprofit organization A Better Balance says that they supported the Pregnant Workers Fairness Act because it requires employees to make a reasonable accommodations for employees who have a known limitation stemming from pregnancy, childbirth, or related medical conditions unless the accommodation poses an undue hardship to the employer. Sapiro-Vinkir had posted about the law onto her popular social media where she regularly discusses reproductive rights. She says she received countless comments from surprised and upset Michiganders. So when 2 organizations, Compassion and Choices, and If, When, How came to her about joining the lawsuit, she happily agreed.
It really should be up to the individual or their loved ones to make those decisions, not the state. It's just a completely inappropriate area for the state to step into and to take control of.
Jess Pesley, a senior staff attorney at Compassion Legal, told me that the pregnancy exclusion still exists in 9 states. The group has sued other states to get rid of it.
We brought a lawsuit back in 2018 in Idaho challenging their pregnancy exclusion, which was ultimately successful and led to a settlement that was really favorable.
Now, I reached out to Governor Whitmer's office. I received a statement saying in part that they cannot comment directly on pending legislation, but that, quote, Governor Whitmer has been a champion for reproductive freedom and led the fight to protect and expand our rights following the repeal of Roe v. Wade when other states did nothing. Now, getting answers for CBS News Detroit, I'm Heath Kalb. Back to you, Terrence.